Now proceed to the third panel discussion entitled Commercial Courts, Insolvency Reform and Investor Confidence in Asia. With that, I would like to invite our moderator once again, Ms. Nolapat Pitpibul Priya, or Ms. Lily, Director of LLB, the School of Law, Rangsit University, together with our panelists of the panel discussion 3 on the stage, Mr. Wan Kai-chi, Mr. Nick Shuril bin Nick Abdullah Rahman, Mr. Mohammad Dawood bin Ismail. Ladies and gentlemen, please welcome our moderator and panelists with the warming round of applause. I will now pass the floor to Ms. Lily to begin the panel discussion.
Thank you very much, Mr. Thanuwat. So, welcome to the afternoon sessions, ladies and gentlemen. Let us get back to the third sessions of the World Judicial Integrity Forums of 2026. I am Nolapat Pitpibul Priya, Director of the Bachelor's of Laws program from Faculty of Law, Rangsit University. And once again, I will be your moderator for these afternoon sessions. And in our third sessions, we shall discuss the topic regarding commercial courts, insolvency reform, and investor confidence in Asia. And we are honored to have the experts from both Malaysia and Brunei as our panelists in these sessions. So ladies and gentlemen, please welcome our first panelist, Mr. Wan Kai-chi from Malaysia. He is co-head of the Financial Service Department and partner of Rangsit Lim and Partners, which also associate with Allan and Glenhill in Singapore. Our next panelist is Mr. Nick Shuril bin Nick Rahman from Malaysia. He is the Director of the Policy and Legal Division of Malaysian Department of Insolvency. And our last panelist for these sessions is Mr. Mohammad Daud bin Ismail from Brunei Darussalam. He is a lawyer, advocate, and solicitor of Daud Ismail Company and the adjunct lecturer at the Faculty of Law of Sultan Sharif Ali Islamic University. Ladies and gentlemen, in order to gain investor confidence and maintain economic stability across Asia, especially in interconnected economies nowadays, the commercial courts needs to play a pivotal role to strengthening commercial court specialization, improving insolvency procedure, especially effectively balancing the corporate recovery and creditor protections, and reducing procedural delays and improving consistency of the adjudications. The court also need to enhance the cross-border recognition of the judgment. And these are the scope of the focus that we are going to discuss in this panel discussion. So without further ado, ladies and gentlemen, I would like to invite Mr. Wan Kai-chi to present his opening remarks.
Hello. Hi, I'm Kai-chi from Rangsit Lim, and we're a law firm in Malaysia, Kuala Lumpur, and we're part of Allan & Glenhill, as mentioned just now. So Allan & Glenhill, we've got offices in Singapore, Vietnam, China, Indonesia. So we have different regional offices, and our focus is we have full service practice, meaning corporate work and litigation work as well. And litigation including restructuring, restructuring all the way to insolvency. And, one of the main practice areas we have and that we help clients with is investment, right? Investment, foreign investment, cross-border investment. And so, of course, this thing is very important when we look at the contracts, investment contracts, M&A agreements. It always comes up, right? Firstly, the clients will look at the country, see whether, whether it's suitable for investment or not. So macro a lot of macro considerations, the business case and investment case. So that always comes first. That always comes first, basically whether they're going to make money or not, based on taxes, incentives, things like that. But also a very important thing, and I think it's been discussed a lot this morning, the rule of law, right? That what you can expect, whether or not, when you sign contracts, when you put in your money, the money is safe, right? So that's, of course, very important, and a lot of times we're talking about millions and billions. So for any country to be able to make sure that investors will come in, that the capital can be attracted, all the correct things need to be in place, and this includes things like investment treaties, right? So G2G arrangements to make sure that if there is some problem, there could be maybe even investor-state arbitration or claims available for the foreign investor. In terms of what we see, daily, that is a practical aspect of this topic is the dispute resolution clause, right? So, of course, we're talking about judiciary now and the courts, and there is the alternative today adopted by many, many jurisdictions of arbitration. So, just looking back, arbitration is a very old thing already, and it's well established, but the reason why it came about is because, maybe a lot of parties felt courts were not working as well as they should be working, meaning, the kind of disadvantages you might have found in the past, maybe nowadays you don't really see those problems, or the problems are different, or maybe the problems are reversed. So often, actually, we choose arbitration, or we talk to clients and say, okay, choose arbitration instead of court. But yes, there are still cases we advise clients use a court dispute resolution. Previously, it used to be things like cost and delay that mean that you want to stay away from court, that you want to go to arbitration. But today that can be reversed. So arbitration can take longer, and the costs can be higher. And in terms of enforcement, arbitration, as I mentioned, there's more and more now being done where it's more easily enforceable, more directly enforceable, and no appeal. So that's pros and cons. There are pros and cons to it. Arbitration, you have a case where it's private, and you don't really go into the situation where there's precedent, right? So there are also benefits. There could be benefits there for certain parties where if you have a dispute and you settle it in a certain way, whether there is a precedent against you for future cases, because in Malaysia being a common law country, that's relevant, whether that there is reported cases for the same point, because then that will be binding on you if you have disputes, similar disputes in the future. So also along the way that we will find that there are various other things relevant for investor protection, and that's, I'll just start with that. Thanks.
Thank you very much, Mr. Kaishi. And now I would like to invite Mr. Nick Sharil bin Nick Apraman to deliver your remarks.
Hello. Good afternoon, everyone. My name is Nick. I'm from the Department of Insolvency Malaysia, or better known as MDI. I realize that this is such a challenging time. I'm referring after lunch. So I try my best to keep things short. My opening remarks is anchored on my slides. I'll be talking about insolvency reform in Malaysia. What we have displayed on the screen is the map of Malaysia, consisting of two key areas, the Peninsular Malaysia as well as Sabah and Sarawak. Okay. Why insolvency reform matters? We want to show that insolvency is no longer a domestic matter. Just like other things, it has stretches across the globe, across jurisdiction, and through digitalization. I want to show the journey that Malaysia has shared. We have managed to evolve and pass through many reforms. We have embarked upon the transformation of personal insolvency as well as corporate insolvency. The traditional approach has been asset realization, creditor recovery, as well as formal winding up. But now the modern approach is rescuing businesses, make it more viable. And the going concern must be preserved. And we also do our best to protect the employment opportunities of people who are in the system. And we want to ensure that there's continuity in economic value. Our reform philosophy is this: saving viable enterprises creates greater justice rather than premature liquidation. The globalization of insolvency, we see that a typical Malaysian company may have creditors in Singapore, assets here in Thailand, financing in Hong Kong, arbitration in London, and digital assets, including cryptocurrency, globally. So without cross-border cooperation, proceedings may become fragmented and localized. The costs will multiply, the time taken will multiply, the value of the assets depreciated, and the judicial conflicts started to contradict and converge. The result would be an inefficient, uncertain, and injustice to the parties concerned. So this is our jewel in the crown, the Cross-Border Insolvency Act 2026. This is based on ANSI trial, model law on cross-border insolvency. Our objectives, as listed there: international cooperation, judicial coordination, recognition of foreign insolvency proceedings, efficient restructuring of multinational enterprises, and this is what people want: greater certainty for investors and creditors. This is our journey. If you would notice throughout this roadmap, it highlights the 9-month period. This is something that the global community is praising Malaysia. This is our landmark achievement. We managed to pass this Cross-Border Insolvency Act within 9 months. Akin to say, I just want the baby without knowing the labor pains. These are the 17 key agencies that were involved from the ideation until the realization of the cross-border insolvency. And you would notice this cut across the board, not just a singular government entity. And the 4 pillars of ancestral model law framework, we have already gone through this discussion in New York last month. And why this reform is historic for Malaysia? There's a paradigm shift. Previously, we rely more on common law principles. Now it's more structured, more recognized regime, more harmonized procedures, and international cooperation framework with other jurisdictions, and increasing judicial certainty. The transition is from territorial insolvency towards cooperative global insolvency governance. The key driving theme of this forum is integrity. This can also be found in cross-border insolvency, where the judiciary as global coordinators can converge in a single proceeding. The recognition of other jurisdictions' decision, this is a game changer. The regional impact on ASEAN. ASEAN can be a hub for insolvency. This is something that we can unlock together. Everybody wins based on this win-win basis. That's the impact. And we hope to drive our neighboring countries to come on board together. Together we can make it with the ASEAN spirit. And everybody knows that the economic and the investment implications, there's a multiplier effect to this. The impact on financial institutions. Everybody likes this. And the impact on the Malaysian legal profession. This creates cross-border insolvency specialists. And like Datuk Nordin earlier in the morning mentioned, that there is a specific judicial academy that has been set up in Malaysia that will be the driving force for this. And the center of main interest. For those who followed the ancestral discussions, they would know that there is already a growing interest in COMI. And we cannot run away from technology. Everybody's talking about it. Crypto assets, AI enterprises, digital platforms, cloud-based assets, and decentralized finance, DeFi. And that would mean asset tracing would be a challenge. We don't want to see another JOLO. The challenges ahead. We need the judges and judicial officers to increase their capacity building, as well as the enforcement. We need more bite than bark. And there is differences in legal traditions and customs, and also the cost of multinational proceedings. We have yet to see this because the Cross-Border Insolvency Act would be enforced in Malaysia next month. The central thesis for justice, reform and resilience, we combine that under the Cross-Border Insolvency Act. It's not just a legal reform, but a total transformation of the Malaysia's economic governance architecture. And this is our vision for Asia. We want to see an Asian insolvency cooperation framework using and leveraging ASEAN judicial insolvency protocols. We want to have a regional recognition arrangements. We want to have a shared judicial training, digital insolvency platforms, this can be done, as well as cross-border court communication mechanism. This will shape on how we want to move forward, a resilient, rules-based insolvency ecosystem for the Global South. The key takeaways from today's session, I would hope to see that the institutional maturity, commitment to the global standards, economic modernization, and the judicial evolution to carry out these tasks. Ultimately, the message is, effective insolvency systems are essential pillars of justice, economic resilience, and global trust. In a connected world, justice cannot stop at national borders. Insolvency reform is therefore not merely economic policy. It is a commitment to fairness, resilience, and the rule of law. I believe this is the common values that we share here today. Kat Kunkrap, thank you.
Thank you very much, Mr. Nick Sharil. And now I would like to invite Mr. Mohammad Daud bin Ismail to deliver your opening remarks.
Thank you, Ms. Moderator. I'm happy to be here today just to share based on Brunei perspective. So it's a privilege for me to be here in Bangkok. Thank you for the organizing committee to basically to invite me to share Brunei perspective on how commercial court and insolvency reform help build investors' confidence across Asia. I think for a start, Brunei believe a strong institution. Independent courts are the bedrock of economic growth. When investors' trust contracts will be upheld, and then of course insolvency process will be fair, predictable. So this forum is basically timely for us to exchange our ideas so that we are able to share the common goal to ensure that the investors' confidence will be upheld. Now, I've just start on commercial court in Brunei Darussalam. I think as you are fully aware, I think we are common law system, and our basically the courts have deep-rooted with the common law, and of course, this system has been considered. In Brunei, I think we are still maintaining our basically with UK, and in fact, we have our courts up to the Free Bid Council. It's something that is a bit rare, but I think it's only in civil cases, and also it will be, it must be agreed upon during the High Court stage. But essentially, I think importantly, I think the commercial court in Brunei, I think the will actually contribute to the confidence in investor. I think what we have, I think it was introduced in Brunei in February 2016. And I think this is important because this commercial court will deal with cases concerning basically the problems or disputes between the parties. And so we have this, what we are having is a speedy efficiency. I think it's important and of course we have specialized expertise. We have judges who are possessing basically in areas such as banking, insurance, and construction, and international trade. Of course, we have also, I think, alternative dispute resolution that is available, arbitration. I think that's very valid, and that is also in practice. But we have our own Brunei Arbitration Center in Brunei. I think that has been important step for us to try to resolve, I think, the dispute between those investors. And in fact, I think the Brunei Research Center is leading mediation, arbitration, and other dispute resolution. Yeah? So, of course, as we have been talking about technology, I think our courts also basically have dealt with this e-judiciary case management, I think, to resolve basically the approach. So with the digital approach, I think we hope to be able to more accessible to local and international investors. Now, as we know, commercial court, basically, we have these issues of, I think Brunei is adopting Brunei Vision 2035. I think this is something that we are hoping to establish Brunei as a stable hub for investment and competitive landscape in Brunei. Yeah? Of course, as I said, the Brunei adoption of the arbitration is one of the areas that we are looking to promote this, promote the basically resolution of the dispute, not necessarily through the court system, but I think through arbitration and mediation. So that. Yeah. Now, looking at insolvency reforms, I think this is an area that my learned friend from Malaysia has spoken very well, but we are also developing this particular area. So we, our insolvency reform is founded in an act, Insolvency Act 2016, very new, but we are looking at this one as to allow, I think that's what the issue of rescuing distressed companies from being winding up. I think this is an area that we are also looking into ensure that the problem company can be rescued and rehabilitated so that the company, problem company can be. So the highlight of this basically of this insolvency reform, there are two areas I think that is important to look at judicial management. The company will look into a judicial manager to resolve the problem that is faced by the company is in trouble. And then there's also, we call it CVA, corporate voluntary arrangement. So this allows the creditors to look into a possible rescue of the company. So to allow it to be. So we have this basically in these reforms. I think I just want to share. This is what we call it shift towards rescue and rehabilitation. I think it is important so that the company will not be winding up. But when we rescue the company, of course, in the end of the day, we are looking into the preserving the business and, of course, preserving the jobs and value of, and also the investors' confidence. Of course, importantly, the issue of having this insolvency reform is to ensure that the creditors are also being protected. I think we look into this, so the interests of the creditors will be protected. And of course, there are issues of receivership work. I think it's like I think was in Malaysia. I think they are now further with we have this cross-border insolvency reforms, but we will be properly looking into the area as well. I think that's important to have a clearer framework for cross-border so that we can resolve it in a more structured manner so that we will be able to look into as well as the. Now, just to conclude in respect of resolving this impact on foreign investment climate, I think what we have here, the synergy between our commercial court and response created basically a balanced legal eco system in Brunei. So we will be able to allow there was enforcement of contract between parties. Of course, there is this issue of trying to, if there is any problem, the early exit. And of course, there is a risk reduces mitigation area. Of course, the foreign investment in Brunei, we have foreign investment, and this reform will be able to allow that. Now, just to conclude this session, we will basically the purpose of having proper commercial courts together with insolvency reform will be basically allow us to see a more better framework, and also that would allow the investment into between the cross-border investment can be improved. That would be sharing the perspective of Brunei system. Yeah, thank you.
Thank you very much, Mr. Daud. So, okay. Yeah. So now we are moving to the panel discussion. So firstly, I would like to ask Mr. Van Kaishi, as an expert of corporate and financial matters of both domestic and cross-border transaction, how can judicial system better support investor confidence through transparent and reliable dispute resolution mechanism?
Yeah, so in Malaysia, we've had many things happen. Including, as my colleague mentioned, Jolo, you all maybe know him. But other things, very big restructurings, big insolvencies, listed companies delisting, having to delist. So, yes, many problems, but of course, a lot of these are not so related to the court, right? So the court does what they do, and a lot of the times it just everything has happened elsewhere, and it's just that there's one part. It's not even everything. Just one part goes to court, and then court needs to say something about it, right? So a lot of the time, it's for parties is the almost on the one hand, it's maybe supposed to be the first resort, but it's also often the last resort where, okay, the regulatory framework, the government action or whatever else could have happened, didn't solve the problem, then you need to go to court to enforce your rights, right? So And you know, there have been some examples of how for parties, right, for companies, you can have practical issues coming up, right? And so one case I would mention is this case which we are working on, and it's still ongoing. It's actually in two parts. There was one litigation all the way up to federal court, and then the counterparty lost. Counterparty is a listed company, Malaysian listed company. And then they tried again. So the company board did a second action against our client. Our client is a foreign investor. So, and so that is still ongoing, and it's under appeal process to federal court. So as you may know, in Malaysia, federal court is the highest court, and it ends there. Before that, it's Court of Appeal and High Court generally. So the issue here, specific issue here, is that after the first litigation, right, there was an AGM of the listed company, and then the shareholders were talking about this thing where you know, the listed company was suing our client, and then they asked, oh, so how much has it cost for us to go all the way to federal court and lose? So the director said 800,000 ringgit, which is about 6 million baht. So lawyers were paid 6 million baht for going to federal court and losing, right? So which is you know, which is what happens. But then the company started the second litigation, right? And so the issue here is that all the time when companies do that, they are spending the company's money. It's not the director's own money, it's the company's own money when they sue the shareholders, right? And so it's not to the loss of the board or the individual directors, because it's not their money, it's the company's money. And what happened for the second litigation is it went to High Court, and the High Court held in favor of the company, this company, to say, okay, directors, when you do this, when you make this claim, it's correct, right? And then it went to Court of Appeal and was reversed. So Court of Appeal looked at it and said, no, 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 this is definitely wrong, right? You were wrong to sue for this, and you know, impliedly, you were wrong to spend the money, because legal fees, you know, I'm a lawyer, but still, it needs to be correctly spent, right? So the issue here, though, is that because the High Court already held in favor of the listed issuer, it's going to be very hard to go against the directors to say, okay, you know, directors have directors' duties. Very hard to go back to them and say, hey, you're in breach of directors' duties, please pay. Please pay back the company, because, you know, the shareholders are the ones who are actually affected. So yes, even though with the court system there's appeal, and you know, it's not so simple that if you are a judge at a particular level to say, okay, I'm just going to decide this way, if it's wrong, somebody else will fix it. In this sort of case, there's an implication, which is, you know, we will be telling our client, no, you can't sue the directors, because if the High Court judge can think that is a correct thing to do, then, you know, you as a director, you're just a regular person, you know, you're not a lawyer, you're not a judge. If you think that's the correct thing to do, then it is, you know, very well justified. So, so that was, you know, just one case I'll talk about that, and it's still a current one, and you know, there are other examples as well, but yeah, I'll just mention that one.
Yes, and how do you think we can solve that in your perspective?
So I think, you know, us as lawyers, we also know judges, right, from our contact, whether from work or from university or as neighbors and friends. So there is like what I mentioned, a little bit of thinking where, and sometimes to say, yes, I'll decide this way, and it's wrong, somebody else will fix it, you know, if you're not federal court. So that shouldn't, you know, you should try to move away from that thinking, because, you know, it can matter.
Okay, Thank you very much, Mr. Van Kai-shi. And now I would like to ask Mr. Nick Sharil, that in this kind of problem, how can we reform to improve the efficiency and predictability of insolvency and restructuring framework across the region?
Okay, number one, you need to have the right law. Number two, you need to have the right people. Whether as a judge, as a lawyer, as a creditor, as a shareholder, as a director. Because court would always be the last resort. Essentially, what we have in insolvency is people are fighting over claims. People are in debt all the time. But once the court, because in the case of Malaysia, the jurisdiction for winding up is at High Court. We have 21 high courts in Malaysia. Where there is a high court, there is a Department of Insolvency. When it comes to winding up, we wear our hat as official receiver. We have liquidators who would scramble for companies that has valuable assets. At the moment, we have about 28,000 of winding up cases throughout the country. And out of that 28,000, 27,000 comes under the purview of official receiver, where we act as provisional liquidator. That means these 27,000 companies does not have any assets whatsoever. This is what I call no income, no asset, NINAS. So how do you deal with that? And companies, it takes its own life. It's a separate legal entity. So there's multiple issues coming at us, not just that. It can be for tax purposes, it can be for money laundering purposes. So you are dealing with this creature, a creature of statute. That's why I say, first you got to have the right law. Once you have the right law in place, you got to put the right people. And for creditors, they just want to get the payment of dividends. And under insolvency, dividends are the proceeds of the sale of those assets. The job of a liquidator, a good liquidator, is to make sure that you sell those assets, you pay off the creditors, and return, if there's any, the surplus to the former directors who are the shareholders. This is where rescue mechanism. My learned friend here talks about judicial manager and the corporate voluntary arrangement. It does not work. When it comes to court winding up matters, parties are at dispute if the company has assets. And in the case of Malaysia, our winding up laws are under the Companies Act 2016. At the petition stage, the court has to ensure that the petitioner nominates a liquidator in the event the court agrees to grant a winding up order. And our finding is the petitioners couldn't be bothered to nominate the approved liquidator. Why? The cost of appointing the liquidator is a lot. So even at that stage, the petition stage, the court, the petitioner, the lawyers who are advising the petitioner must know that you do not simply wind up a company. Lives are at stake. Livelihoods are at stake. When company goes down under, they pay no tax to the government, and the government earns nothing. So that affects the whole ecosystem. At the very beginning, you have the financial stability laws, where banks can go through the credit assessment system to grant loans. And banks, they are earning their profit through those loans. But what happens if there is a default in loans? So this is the whole ecosystem from beginning to the end. We are not just taking this on a compartmentalized approach. No. Most countries, you have a very established entry system. Banks love giving loans. That's why they survive. But when it comes to default, they quickly put in their claims. And they know for a fact that the companies no longer viable. NINAS. And you don't expect liquidators coming down and sweep up everything for the benefit of creditors. This is where the official receiver in Malaysia plays that part as a social balancer, the equalizer. Because most of these companies are small and medium enterprises. You know? So the spectrum of issues converges. So this is where we try to unpack and try to get the low-hanging fruits first. This is where also we want to ensure that there's no preferential treatment over a bigger creditor than a smaller one, as well as a foreign creditor over local creditors, because essentially you want to make sure that the foundation is right. So to answer your question, I'm sorry, there's no short answer to that. It's not a yes or no. It requires another session, perhaps nearer to Sukhumvit. All right? Thank you.
Thank you very much. So you have mentioned that we need a good law and a good court with a long answer. Can I have example of the jurisdiction or any system that you think, okay, maybe not so perfect, but close to a very good models that Asian regions we can follow? It doesn't have to be within Asian, or it could be Malaysian. Or it could be
Okay, a good example would be Luxembourg.
Oh, really?
That's my short answer.
Luxembourg.
Yes.
How? In what aspect?
Okay, they have already established a creditor regime that is very efficient. They have been doing that for the last century. And for your information, MDI is 102 years old. We were established in 1924. But that's how old our system is. We do not move with times. That's why when the cross-border insolvency were passed by Parliament, we have built into that would be our game changer. Everything would have to be digitalized. So taking a leaf from Luxembourg experience, everything is digitalized. So you can do asset tracing. Okay. You know, you follow the breadcrumbs. And not forgetting other laws as well, not just insolvency. You got to have your tax system in place. You got to have your money laundering system in place. This all comes together as a package. So what we do here, from what we can do, is just focusing on insolvency, but we need to harmonize it, not just at the national level, regional and international. So Luxembourg sits just nicely within Europe. But how they do things there, I can tell you, but not here. Thank you.
Yeah, it's about the culture as well, right?
That's right.
And they are a small country.
Yes.
So can we really follow them, as you know, most of us are developing countries with lots of populations and different cultures? Do you think?
Yeah, because legally they inherited the civil system, the continental system. Whereas in Asia, you are a hodgepodge of many systems. There are some civil, there are some common law, there are some hybrid. So that's the challenge, even at ASEAN region, you know. But we have the ASEAN platform. We can talk, we can discuss in the ASEAN spirit, because we have the same objective. So the devil are in the details, as always. But, you know, as Confucius said, a journey of 1,000 miles starts with a single step. So I believe today is our first step towards that same journey, same direction. Together with that can-do spirit, you know, when there is a will, there's a way. Thank you.
I believe so and hope so. So we can use them as the guideline and we kind of adapt what we can take, right? So I would like to ask Professor Mohammad Daud that what are the key challenges in reducing delays and improving consistency in the commercial dispute resolution? Let's get into the practical approach.
Well, that is a tough question. But basically, I think, of course, in ensuring that the dispute should be settled without delay, because if you are looking into disputes, I think there are many challenges to be faced. I think basically, if delay dispute will cause numerous challenges. Basically, okay, the parties will be having unhappiness and trying to of course creditors will be running up to you. Of course the court will have to decide on this. So I think basically it is important for parties to look into how to resolve the dispute in a speedy manner. When a speedy manner, meaning that I think try to go work out. I think don't go to the court. The court is the last resort. So it is important for us, for I think lawyers to seek. I think initially, I think we are in Brunei. We are recommending parties for mediation. Mediation is one of the basically court assisted mediation. But if not, then we can go to the Brunei Arbitration Center, or we have an arbitration that can be conducted not only in Brunei, but it can be conducted in Singapore or any other forum that is agreed by parties. I think the main problem that we are facing is if I think the parties should be encouraged. I think in Brunei the court encourage mediation to be considered in the first instance. Let parties work out their differences and let parties to do that. But in the event that I think court system mediation fell, and then it can encourage the arbitration. I think arbitration to look into a possible resolution of that problem by way of arbitration. I think that would encourage parties to come to us. Because as I said, the challenges of having a protracted dispute, I think it is bad for the parties. Of course, in the end of the day, the court will come to the rescue to resolve that. But I think that is not. I think the court may have to decide one way or the other. So sometimes I think it is good for parties to come to an amicable settlement, either by way of mediation or by way of arbitration to resolve the matters. Yeah.
Thank you very much for a perspective. And now, may I ask from your perspective as well, like how do you think we can solve, such challenges in reducing delays and the consistency of the commercial court dispute in your perspective? You have anything in addition?
Well, I think for commercial matters, and I think also maybe part of what this topic had in mind, the issue of more and more specialization, right? So in Malaysia, there are many different types of specialization for courts already, whether you talk about industrial cases or maritime or specific courts with the specialty. So I think somebody did mention that judges need to be good judges, but also there are some of this that other things that come in, right, which is how for whether it's arbitration or the court system, and you have the technical disputes, what happens is you need to bring your expert witness, and if it's about a certain construction thing or engineering thing or whatever, then you have the experts saying what it is. What some people say, what they're chosen chosen to say or paid for to say, but of course they're experts and they need to do it properly, right? They need to give the evidence properly, and compared with arbitration, where you can have a tribunal with experts, not only those who are legally qualified, but so within the tribunal as well, you have people who have that expertise. So of course, with with a court system, you have that as well, right, built in, and of course the issues there. I suppose there are some operational issues about resources, right, and all of that. And if there are enough cases, then yes, it'll be worth doing. And I think that's what we're seeing more and more of in the region, including Singapore and other places.
Okay, she reminds us already that we have 5 minutes left, so I briefly ask maybe Mr. Nick Sharil of how can court balance creditor protection with the need to facilitate corporate recovery and business continuity in terms of balance?
Okay, to keep it short, 3 things. Number 1, judicial trust. Number 2, institutional integrity. And number 3, regional cooperation. Thank you.
How about you?
I share the views. I think it's important for the court to play a good role in trying to resolve the dispute. Of course, in the end of the day, I think the cooperation is required. I think in order to have maybe regional cooperation is important for us to resolve, because basically investor confidence in Asia will then have to be try to be resolved in the best possible way by cooperation.
Thank you very much. We are concluded for this session. So I would like to thank you, every panelist, for this fruitful discussion. Thank you very much.
Thank you very much once again for both the moderator and the panelists. And again, may I invite Mr. Siwai, Director of the International Strategy Institute, to provide the token of the appreciation to the panelists. Thank you very much once again. This will be a very, very interesting issues that we have been talking in this afternoon. So right now we need to prepare for the next session. That would be the last session for our forum here today. So for the forum 4 of today would be about the strengthening judicial cooperation, cross-border legal coordination, and institutional exchange. With this kind of topic, that would be a very, very interesting. Okay, for right now, we have a short time to make a short brief break. So we would have around 3 minutes to wait for another session. And to get a bit break after a very long session of the very fruitful situation that everyone would keep listening to. cooperation, cross-border legal coordinations, and institutional exchange. With that, I would like to invite our moderator once again, Ms. Lily, on the stage, together with all the panelists here today. Mr. Philip Theo, Police Captain Amon Pan Niti Tiranon, Police Lieutenant Colonel Boragon Natta Mangkang. Ladies and gentlemen, please welcome our moderator and panelists with a round of applause on the stage once again. I will now pass the floor to Ms. Lily to begin the panel discussion.
Thank you very much, Mr. Thanuwat. And now, ladies and gentlemen, we have commenced into the last sessions of the World Judicial Integrity Forums of 2026. So, my name, once again, is Nolapat Pipunpriya. I am the director of the Bachelor's of Laws program, Rangsit University. And I will be the moderator for your last sessions here. In these sessions, ladies and gentlemen, we are going to commence in regarding the strengthening of judicial cooperation, cross-border cooperation, and institutional exchange. And we are honored to have the expert, both from Malaysia and from Thailand as well. So ladies and gentlemen, please welcome our first panelist, Mr. Philip Theo from Malaysia. He's partner, international lawyer, and arbitrator of ASMI and Associates. Our next panelist is Police Captain Amon Pan Niti Tiranon from Thailand. He is former judge and currently the Senior Advisor, Acting Assistant Secretary General of Personal Data Protection Committee. And our next panelist, even though she's not here today, but she sent us the pre-recording of her remarks. She is Ms. Li Yujie from China. She is researcher of China ASEAN Legal Research Center, Executive Deputy Director of the Overseas Interest Protection Center of the Southwest University of Political Science and Law, the residence expert of Chongqing International Center for Policy and Legal Service of Airport Economic Zone, and also the foreign legal expert advisor of Southwest University of Political Science and Law, China ASEAN Legal Research Center. And our final panelist for these sessions, ladies and gentlemen, is Police Lieutenant Colonel Voragon Nattamangkang from Thailand. He serves as Inquiry Inspector and Investigator in the subdivision of the Investigation Division of Thai Immigration Bureau. Ladies and gentlemen, as Asian countries become more connected, it is inevitable that we have to strengthen our judicial cooperation, especially in terms of the cross-border legal coordination and institutional exchange. So in these sessions, we are going to tackle the practical mechanism of judicial collaboration among Asian jurisdictions, including procedural collaboration, information sharing, and judicial training. And we're also going to discuss how to promote the international collaboration, deepen legal understanding among Asian courts, while respecting the national sovereignty and distinct legal system and legal tradition of each nation. And we hope to gain this practical approach from our panelists today. So without further ado, ladies and gentlemen, I would like to invite Mr. Philip Teo to commence his opening remarks.
Good afternoon. I am pleased that I've been invited to speak at this conference. What I have heard so far this morning is contribution from experts from different countries. And you can have integration of the legal aspect and the judiciary system in ASEAN. Before you have integration, you must first have understanding. And the understanding, we must try to understand how each country's laws operate, how each countries decide cases through their own judiciary or through other methods of dispute resolution. So this includes very prominently arbitration. And each country have their own arbitration center. In fact, several years ago, I argued a reinsurance dispute in the Thai arbitration center concerning Thai reassured insurance company against a Malaysian reinsurer. And in Malaysia, we have our own center, the AIAC. And in some countries, there's more than one center. In fact, the countries of China, they have multiple centers. Countries of India, they have multiple centers. Actually, in this area, more is not necessarily better. It confuses the user. It confuses the business. So to a large extent, a lot of Indian businesses refer their cases to the Singapore Arbitration Center. I want to give some overview, which my slides will present. So the Malaysian legal system, like Singapore, like Hong Kong, we have what is called a colonial past. And because of a colonial past, a lot of the laws of Malaysia have British origins. Example, I do a fair bit of shipping. The merchant shipping ordinance derives its origin from the Merchant Shipping Act, UK, 1894. Malaysia also have a Contracts Act. Our Contracts Act derived from the Indian Contracts Act, 1894, which is a codification of the English common law. And in fact, in many areas, we still have a continuing reception of English law. For example, there are provisions in the Civil Law Act, and when you insure cargo or ships under marine insurance, the forms of insurance, they use English forms. And in the English forms, you have what is called a choice of law, choice of English law. This raises the issues of conflicts, which I will cover in a short while. Malaysian courts are courts in the common law tradition. Our courts are run on the adversarial basis. As contrast to courts in Indonesia, courts in Thailand, because the Indonesian and Thai courts are of the inquisitorial system. And in Thailand and Indonesia, you have what is called a civil code. In 2012, I argued in Singapore a breakdown of a joint venture dispute where the agreement was subject to Indonesian law. And under Indonesian law, the whole dispute had to be tried under the civil code. And actually, Malaysian courts and arbitrators too, we can apply foreign law. So in the arbitration case, what happened was, I'm the counsel, and the three arbitrators were mainly common law lawyers. However, the arbitrators were still able to decide under the applicable governing law. And how did they do that? Parties had to bring in the expert foreign law experts, and they brought in, each of them, lecturers from universities of certain repute. Similarly, in the Malaysian courts, if there is a dispute and the contract of the parties in dispute, say, apply Chinese law. So what? Of course, the judges, the Malaysian lawyers, will not understand Chinese law. Again, they will bring in experts for that particular law. However, if the matter concerns English law, to a great extent, we can refer to textbooks. And understanding the different laws, applying the different laws when there's an issue. Obviously, if you have a breakdown of a joint venture between a Thai party and a Malaysian party, the first thing you need to do is look at the contract. Is the contract subject to any particular law? And you will decide how to go about resolving the dispute under that particular law. This is the issue of conflicts of law. Conflicts of law is very important in this area. In the two main areas which I handle, international arbitration and shipping, it always rises. For example, the cargo which is carrying the Malaysian exporter's ship is a Japanese carrier. Okay? The Japanese carrier, under the contract, the bill of lading provides for any dispute, it should be filed in the Tokyo District Court. And the other aspect about dispute between companies of different nationalities, one must realize, after the dispute is tried, how are you going to enforce the dispute? Actually, the courts are not so, how to put it, efficient universally. Malaysian court judgments are recognized in very few countries, and the countries are Singapore, Hong Kong, several states in India. However, if you have an arbitration award between an Indonesian party and a Malaysian party, that award can be enforced in 172 countries under the New York Convention. And to a great extent, the courts in Singapore and Malaysia are arbitration friendly. So again, this is a conflict issue. If in the contract there's an arbitration clause, you bring the case in the Malaysian court, the judges, upon application by one party, will say, look, this is not a proper forum. You go to arbitration. However, certain actions can be taken in the Malaysian court. For example, ship arrest. And in fact, that also brings me to one particular topic. The newly set up division of the Malaysian court, International Commission, ICAT. Basically, what this court, which is a court in the KL High Court system, it decides on disputes between foreign parties, and it also subsumes the jurisdiction of the former Admiralty Court. This is ICAT. I do appear quite often. In fact, 3 weeks ago, we arrested 2 vessels, and up to today, while I'm here, my lawyers are having cases before the judge. So ICAT was set up in 2nd of March this year. And according to the Chief Justice of Malaysia, the purpose of ICAT is to try cases involving foreign parties and as well the Admiralty Court. The Admiralty Court was set up in the year 2010. The very first Admiralty judge was Tan Sri Nalini, who later became the Federal Court judge. She retired sometime in February. And I've been trying cases before her court. In fact, I argued the very first reported case of her court. So what is the whole purpose of the Admiralty Court? The whole purpose of the Admiralty Court is to have a court where there is expertise by the decision maker, and in fact, by virtue of the establishment of the court, it also helps to promote the maritime lawyers' expertise. What is the difference between Malaysia as a common law jurisdiction, the adversarial system, and the civil law inquisitorial system? In fact, the prominent aspect is the court and the judge is independent, impartial. In some civil law courts, the judges have what is called an inquisitorial role, meaning they will investigate issues which may not have been fully raised by the parties, but the Malaysian courts do not do that. It is left to the counsel of both parties to raise issues for and against their case. And I heard this morning about advancement technology. The Malaysian courts are very used to online hearings. So if you have trials, what the courts have done, if they have reverted back to physical hearings. However, if you have interlocutory applications, these still are commonly handled through online hearings, through applications like Zoom. And this advancement after COVID saves a lot of time. In fact, previously, if we have what is called a case at the case management stage, we had to go to the court and wait from 9 a.m. to 12 o'clock because the judge will be hearing other cases. So we have to be in court. However, now, where we can have the hearing by Zoom, we can be in our office. We can, in a way, not save time on travel, and also be able to do other matters before our hearings start. And this is a security for cause application hearing, which I handle with my lawyers. Before the case goes for trial, the Malaysian courts would have what is called a court annex mediation. In a court annex mediation, the parties are given a chance to refer the case to a different judge, a judge who's not going to try the case. And what the judge will try to do is try to explore both parties' case. However, the role of the mediating judge is not to try the merits before the trial. He is trying to convince the parties to come to a compromise. For compromise, and if the mediation succeeds, parties will enter into a consent judgment. If it fails, then what happens is it reverts back for trial. And because we have an adversarial system, you need to bring witnesses. Witnesses, whether the particular persons are cogent, they have personal knowledge of the matter. This is important. If the witnesses are brought of crucial facts, then you have a loophole in your case. And we also use what is called witness statements. Witness statements are very important. In fact, these are prepared by lawyers. But as lawyers, we need to go through with the witness. I had several cases where I cross-examined parties. You look at question number 3, referring to this document before the trial. Have you seen this document? And that witness says, no. Then there was another case, a case where dangerous goods cargo exploded, sinking my client's ship. The chemist gave 4 pages of the packing. I asked, were you present during packing? He said, no.
We have to conclude.
Yeah. And this is arbitration. What's the main difference in arbitration is that the person who decides is a chosen dispute resolver, and this is chosen by the parties. Yes, I think I've come to the end of my presentation.
Okay. Thank you very much, Mr. Philip Teo. And now I would like to ask Mr. Amonpan to deliver your remarks.
Okay, good afternoon. I will share bridging the gap in a borderless world. Now, the first, we want to know what the key challenge faced by the ASEAN judiciary in strengthening cross-border legal cooperation. I see in Malaysia have online court, but do you know in Thailand, in Thai law, the online court hearing is allowed for domestic only, not for international hearing. When dispute enter our court today, they are rarely confined without our border. We face distinct challenge in both criminal and civil sphere. I think Police Colonel Lieutenant Waragon will share in criminal sphere, but now I want to share in civil proceeding. The primary obstacle is the service of judicial document. You can see example in this slide. Courts often rely heavily on diplomatic channel, and this process is slow now. Even more challenge is the execution of judgment and seizure of assets because the court authority general end at the nation border. In Thai law, to resolve this issue, we must embrace 3 pillars of reform: harnessing technology, aligning domestic law with global standards, and building 24/7 network and data integrity. Okay, the next topic is I want to share the handling cross-border commercial dispute. How can judicial coordination will be improved to reduce uncertainty and delay? That I say that the most problem is the delay for document legal. One of main challenge in cross-border commercial dispute is delay. I know many people may have heard the saying, justice delay is justice denied, right? Especially when courts need to send legal document about or enforce judgment in another country. To improve this, ASEAN countries should strengthen judicial cooperation, use more digital technology system and electronic communication, and continue improving legal coordination between jurisdictions. I know now Thailand have cooperation with another country, only 6 countries in judicial legal. And the low technology and digital platform play in facilitate cross-border judicial cooperation. We must use technology to bridge the time gap in international law. Technology can improve communication, evidence sharing, and coordinate between jurisdictions. Within our court, we are expanding the electronic service of process and verify digital system. We can reduce notification period from month to month day. As my office of we call the PDPC Thailand, we regulate the personal data protection. We also see that international cooperation must move toward real-time information exchange. Under our framework on technological crime, financial institutions and telecommunication providers are able to exchange information more rapidly to assess suspicious transactions and cyber-related offenses. Globally stronger digital cooperation and secure information sharing system will become increasing important of effective cross-border judicial cooperation.
So now I would like to invite Police Lieutenant Colonel Varagon Nathamangkang to deliver your opening remarks.
Okay. I'm not the academia. I'm the practical officer that I will say that something in reality, the problem, the conflict about the border enforcement and humanitarian protection. I attend 2 international conference in 2019 Trans-Commissional Conference, and then the last year, the ASEAN Pole Conference. I want to tell you that everything has changed so far for the situation about the crime in ASEAN and its impact internationally. So we will talk about the problem in current situation. Now we know that the ASEAN is a very popular region from the world now. We have the several countries, several legal systems, several courts, several believe it. It's very diverse. If compared to the other region of the world, you see that the Thailand link up to the land border to the Myanmar, Laos, Malaysia, and Cambodia. In the maritime of the ASEAN, we have the naval border connect to the Indonesia connect to Malaysia, and Brunei had a land connect to Malaysia. So why is the problem is complicated? what I saying about is the national security and human rights obligation. In the three pathways of the judicial system of the ASEAN, we have three pathways. First is a domestic legal system, and international relation, and the law enforcement between the country. What is the problem? Because the national security in each country in ASEAN have own agenda. Moreover, we have the United Nations treaty or agreement that to accept. Right in Thailand, for example, we signed the refugee treaty to accept the refugee. But in reality, we did not write any law to support them. I think it's a worldwide problem. So when the UNHCR accept the refugee, they are also overstay in Thailand, and police can catch them and go to the court, to the judicial system, and judicial sentence them, get the penalty, and the judge lead them to the public. It's a loop, right? This endless loop. What's the problem of the judicial court in ASEAN? Not only Thailand. Why is happen? There's someone that evac from some country to enroll to be the refugee, but the local legal system doesn't support them. What's it happen now? It's a question that everybody should answer. Now, today, you will see that the asylum seeker, the refugee, and the normal criminal, that we should identify first what is happened, what they do, what they did, what is the real problem behind them. Some country require the criminal in Thailand, but they have double status. They are the criminal of some country and the refugee of the UNHCR. This is the recent problem of the international relation today. And now, furthermore, the problem is more complicated because it have the scammer and human trafficking, modern enslavement. The problem that we had to identify them. What is the victim? What is the criminal? It's a very sensitive issue now for law enforcement and legal system that challenging us today. You see that? The autonomy of human trafficking, recruitment. Somebody, maybe outside ASEAN, around the world. I met them every day. Bangladesh, India, Brazilian, somebody from African, Nigerian, went to some country in ASEAN and did the bad thing, like the scammer, to scam and get the money from somebody in Japan, Spain, England, UK, United States. The question is, they did in some country. They scam, they had the base on some country. they have the compound for some country. And they scam also people in some country very far away, but connected by internet. Which area of legal system that in charge them? This is a problem. Then I encounter today many cases. This is a question that without the answer today. How do court respond to them? Now, the problem is more complicated. When we, in terms of issue of the human trafficking law, if they are victim, but they also did the crime, committed a crime, how we identify them? If they are the victim, we have the process for the protection to the court, to the judicial. So, who are them? Criminals or victims in legal system? How do you know that they are innocent? They just go because they earn wealthy, earn good income, or they intend to attend the criminal organization. This is a question that judicial system should answer. How to identify, how we protect the innocent, how we sentence the criminal. It's not the problem is not already ASEAN. You say that in the red line, confirm is a victim trafficking, but somewhat but in general line, it's very important because we know is a criminal or victim, but we have no evidence because the evidence is far away in another country. How the judge can believe them? They torturing, they scamming. How is the weight of the evidence that judge should identify them? And I want not to talk about the Burai because it's very clear that it's not a victim or anything. But the problem is not the court, the different method about the judicial system, but we also have the United Nations commitment. There's a problem. The question is, we have the global standard and the domestic operation. And I forget to put it in the slide is the regional operation. Like I attend the conference. It's really a complicated problem. Sometimes the criminal that some country claim they are the criminal, but in some country it's not the crime. That's a problem because but sometimes it's a political opinion. The armed groups or insurgent, religion persecution, race, ethnic violence. But the UN accept that. But in the local law system, they are the criminal. They did the crime. How about the question? How about this problem? What would be next in Thailand? I think it's the same. It's around the world. When we have some time, we have the somebody that did committed a crime and we remove and depart them back, but some term is not about the overstay or committed a crime in the form of local, but it's the government is the far away not require us to catch them and bring them to the system. In the history of Thailand, we have one case that very popular, that when we want to depart, which country that depart is the case of the Mr. Victor Bush. He's the armed group, not armed group, it's the armed merchant. He the citizen of the Russia, but the United States want them to bring them to the United States, to the judicial system. And this case had brought to the Thai legal system, and court justified that between Thailand and United States have obvious protocol, obvious treaty we signed about the criminal. So then the court depart them to the United States. In also way, Russia also veto us that the United States use the political pressure under the Thai court. So the question is, which country that have the legitimacy to bring them? You see that the border control is very, very complicated and very important. It's about security and service. Two pathway, two issue, very big issue, but it's very contrast. How we maintain the security and also provide the service. You see that the slide with a pipeline about diverting. Now, I think it's for the conclusion. The problem is not only the problem of the difference between the legal system from each country, but we also have the United Nations agenda to accept that, because we are all the members of the United Nations. And finally, I think the question that we should discuss in this forum, that how we accept the middle way together. What is the middle way? What is the consensus of the legal system that we can accept together?
Today, on the topic of strengthening judicial cooperation through cross-border legal coordination and institutional exchange, with a particular focus on the China-ASEAN region. I will also extend this discussion to an emerging yet underexplored issue: the regulation of private security actors in cross-border contexts. In recent years, the intensification of economic integration and transnational mobility between China and ASEAN has not only facilitated regional development, but has also generated increasingly complex legal challenges. Transnational crimes, including telecom fraud, human trafficking, and cyber-enabled offenses, have expanded both in scale and sophistication, raising significant concerns for regional governance. This development suggests that purely domestic legal responses are no longer sufficient. Current regional trends further illustrate this growing tension between deepening integration and expanding cross-border risks. China-ASEAN trade has continued to grow rapidly in recent years, exceeding $1.2 trillion in 2024. At the same time, cyber-enabled fraud and transnational crime activities across Southeast Asia have also increased significantly. This development demonstrates that closer regional connectivity not only creates economic opportunities, but also generates more complex legal and regulatory challenges that require coordinated judicial responses. Against this backdrop, judicial cooperation has evolved from a technical legal mechanism into a central component of regional governance. This transformation can be understood through the lens of non-traditional security. Rather than focusing solely on state-centered threats, cooperation increasingly addresses transnational risks that cut across jurisdictions and involve both state and non-state actors. Existing frameworks between China and ASEAN already reflects this shift. For example, the China-ASEAN Plan of Action 2026 to 2030 places explicit emphasis on mutual legal assistance, prosecutorial collaboration, and judicial capacity building, alongside the institutionalization of regular exchanges among legal professionals. Such initiatives indicate a gradual movement from fragmented national responses toward more coordinated regional approaches. Moreover, cooperation has expanded beyond traditional crimes to include cybercrime and financial crime, reflecting an ongoing shift toward more integrated and institutionalized forms of governance. Recent developments in regional security cooperation further demonstrate this trend. Along the Lancang-Mekong River, China, Laos, Myanmar, Thailand, and Vietnam have institutionalized joint law enforcement patrols and established integrated security cooperation mechanism to combat cross-border crimes such as drug trafficking and telecom fraud. At the same time, ASEAN and China continue negotiations on the South China Sea Code of Conduct, which aims to provide a more stable and rules-based framework for managing maritime disputes and reducing regional tensions. These initiatives reflect a broader shift from fragmented responses towards more coordinated and institutionalized regional governance. However, despite these developments, significant challenges remain. One of the most persistent issues lies in the diversity of legal systems across ASEAN member states. Combined with China's distinct legal framework, differences in evidential standards, procedural norms, and extradition practices continue to complicate effective coordination. As a result, cooperation often depends on ad hoc arrangements rather than fully harmonized legal mechanisms. It is within this evolving landscape that the role of private security actors become particularly salient. As Chinese overseas investments continue to expand across Southeast Asia, private security companies are increasingly involved in protecting assets and personnel. Recent regulatory developments illustrate both the opportunities and risks of this trend. For instance, Myanmar's Private Security Services Law, enacted in 2025, establishes a legal framework for the operation of both domestic and foreign securities providers, while requiring coordination with state authorities. This raises important questions. Private security companies operate outside traditional state law enforcement systems, yet they play a growing role in cross-border security governance. Without proper regulation, this may lead to unclear accountability, blurred enforcement authority, and potential human rights concerns. In light of these challenges, it is increasingly important to broaden the scope of judicial cooperation beyond traditional state-to-state mechanism. This may involve developing shared regulatory principles, enhancing information exchange, and establishing clear frameworks for supervising non-state actors operating across borders. At the same time, strengthening judicial cooperation also requires sustained investment in legal capacity building. This includes expanding judicial training programs, promoting cross-border professional exchanges, and supporting the development of international competent legal professionals. Such efforts are essential for improving mutual understanding and ensuring effective implementation of cooperative frameworks across different legal systems. In conclusion, judicial cooperation between China and ASEAN is undergoing a significant transformation from a set of technical legal interactions into a more comprehensive system of regional governance, addressing emerging challenges, particularly those associated with private security, will require deeper legal coordination, stronger institutional trust, and a more inclusive approach to regulation that reflects the evolving nature of cross-border security. Thank you.
Thank you very much. So now we are having some time left, a little bit, for the panel discussion, approximately 5 minutes. So we are going to ask and answer in brief, okay? So for Mr. Philip Teo first, is it possible that we could have a recognition and enforcement of foreign judgment across Asian jurisdiction, or we do have to strictly respect the sovereignty of each jurisdiction?
It's not so much respecting sovereignty. It's having the statutory framework. So if you want to look at, example, Thailand, the Thai court judgments, Thailand has to enter into a reciprocal law or arrangement with other countries. Because, example, Thai judgments are not recognized in Malaysia. It's only if the Malaysian recognition and enforcement of Judgments Act includes Thailand. But it will not include Thailand if Thailand doesn't have a similar law. So that is why arbitration is the logical way to have judgments recognized and not so much judge, it's called awards actually, recognized and enforced.
Okay, thank you very much. And now moving fast to Mr. Amon Pan, that I would like to ask that nowadays, what are the most significant challenges and obstacles in Thai judicial process when the international dispute reach the court? And how should we strengthen cooperation with the international community to effectively overcome such issues?
Okay, I just say that and show in my slide there's very challenges when the dispute enter our courts today is about very conflict within our border. We face distinct challenge in both criminal and civil spheres, such as when we send legal document. Sometimes we use 6 to 12 months for one document. We need to translate and set it in diplomatic channel. And in criminal sphere, Mr. Walker shared as human trafficking. I will share an answer about extradition. In Thailand, we have the extradition law, but in real practical, we use deportation in Immigration Act. Don't use the extradition law because it used many more time and sometimes it exception about the political criminal and social criminal. I think that many countries use the diplomatic channel, not in court channel. Back to the civil sphere, I will think to resolve this problem, we need to have the cooperation in ASEAN country. We need to have 24/7 and networking. We at the last year, Thailand signed the UN Convention in criminal Asian crime as the Vietnam. We need to use the technology, digital system to share the digital evidence to at the court. And I think this is not digital system only. We need the security. It's very important for the legal document to comply with cyber security law and cyber security standard. It will help the gap time to from the many time will shortly.
Okay, so Mr. Waragon, in brief, we have only 1 minute left. So you have mentioned many key challenges, okay? So what is the most critical way to solve such challenges that come in your mind, like the most crucial one?
The most crucial one is we must accept that the politic is the very important, the most important from the judicial system, international judicial system, because it's sometimes very sensitive. For example, I went to the European Union. The commitment is different from the ASEAN. It's a hard commitment. They have court, they have parliamentary rigorous system about the EU, but ASEAN don't have. ASEAN, when have the conflict between the raw or immigrants, that they use the diplomacy. They use the soft way to solve the problem. The critical thinking, the critical problem is about how is the relation between, how the commitment between the nation. If we can answer this question, we will answer the problem of the all thing. Thank you.
Thank you very much, all the panelists. And now I hand the stage back to Mr. Thanuwat for the appreciation section. Thank you.
Thank you very much, Ms. Lily, for a very, very fruitful discussion together with all the panelists here. And again, before we proceed to another, excuse me, please remain on the stage. So right now, I would like to invite Dato Siti Harjini Suhaimi bin Nik Suholaiman, Organizing Chairman and Legal Advisor to the International Strategy Institute, to present the token of appreciations to our panelists. Take a good photo together. Thank you very much once again for our moderator and panelists for the last session. Ladies and gentlemen, right now we are going to the last section of our forum today. And I hope that all four sessions for today could be a very fruitful and just make some thoughts happening in your own minds to rethinking about the judicial integrity as we have this topic in our forum 2026. We may need to have some time to prepare the podium before we going to the closing ceremony. Ladies and gentlemen, we will now proceed to the closing keynote address. It is my honor once again to invite Professor Visha Mahakun, Dean of the School of Law, Rangsit University, Bangkok, Thailand, to deliver the closing keynote address. Please welcome.
Good afternoon, Your Excellencies, distinguished members of the judiciary, esteemed speakers, colleagues, ladies and gentlemen. As we come to the end of the World Judicial Integrity Forum 2026, I would like to take a moment to reflect on what we have shared today. It has been a full and meaningful day. We have heard different perspectives, exchanged views, and discussed issues that are highly relevant to all of us: judicial independence, the impact of technology, commercial disputes, and cross-border cooperation. What stands out most is not just the topics themselves, but the diversity of experience behind them. Each of you comes from a different system, a different context, and different stage of development. Yet, despite this difference, many the challenges we face are increasingly similar, and perhaps that is what today has reminded us. Maintaining judicial integrity today is not only about principle, it is also about how we respond to change. Whether it is technology, increasing expectations, or more complex cross-border issues, the role of judiciary continues to evolve. But at the same time, the foundation remains the same: fairness, independence, accountability. These are not new ideas, but they are becoming more important than ever. Today's forum has allowed us to step back, to listen and to better understand how others are dealing with similar challenges. And I believe that is where the real value is. Because in many cases, there is no single answers, but through dialogue, we begin to see what works, what can be adapted, and what should be strengthened. As we leave this forum, the discussion should not stop here. What we have heard today should continue within our own institutions, within our own work, and within our own systems. Whether it is improving processes, strengthening practices, or simply rethinking certain approaches. These are the small but important steps that contribute to the stronger judiciary. I would like to take this opportunity to thank all our speakers and panelists for sharing their insight and experience. Your contributions have truly shaped the depth of today's discussion, have truly, and to all participants, thank you for your presence and engagement. It is your participation that makes a forum like this meaningful. And the last, not the least, I would like to express my sincere thanks on behalf of Rangsit University and School of Law. Thanks to ISI that collaborate with us again as a co-host for WJIF 2026. Our partnership will further strengthen both the regional impact and working closely together in the future. Before I conclude, allow me to leave you with one final thought. The environment around us will continue to change, especially technology will continue to advance, but the responsibility to the judiciary remains constant, and that responsibility rests with all of us. With that, I wish all of you a safe journey home and continued success in your important work of every country. Thank you very much.
Thank you very much, Professor Visha, for your keynote address. So right now, Professor Visha, please remain on the stage for the presentation of the token of appreciation. And I would like to invite Mr. C.Y. Jia, Chairman of the International Strategy Institute, to present the token of appreciation to Professor Visha. Thank you very much once again, Professor Visha Mahakun. Ladies and gentlemen, as the World Judicial Integrity Forum 2026 now comes to a close, we invite all guests to enjoy the closing coffee break before departing. On behalf of the organizers, thank you very much for your participation, presence, and valuable contributions throughout today's forum. We sincerely hope today's discussions have provided meaningful insights and strengthened continued dialogue and cooperation among all participants. Please enjoy the coffee break and take this opportunity to further networking and engagement before departure. Thank you once again for being with us today. I am Thanuwat Rinanon, your Master of Ceremony for today, signing off on behalf of the organizing team. We wish you a pleasant evening, safe travels, and we look forward to welcoming you once again in the future. Thank you. สวัสดีครับ